District of the State of Florida is now in session. The Honorable Ron E. Lambert, Judge presiding.
Choose to read the name.
All persons having business before this court draw near, give attention, you will be heard. You God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Thank you. Good morning. Welcome again to an oral argument session at the 5th DCA. As our marshals indicated, I'm Judge Lambert. I'll be presiding over the panel this morning. Let me introduce the panel for you. To my right is Judge John Harris, and to my left is Judge John McIver. We have one case remaining on the docket. It is case number 23-3366, Florida PACE Funding Agency, a public body, corporate and politic, versus Will Roberts as Volusia County tax collector. All right, each side will have 20 minutes for oral argument. We typically reserve 5 minutes for the appellant for rebuttal. If you want a different amount of time, let me know and I'll adjust the clock accordingly. You'll see when you're going into your rebuttal time, the yellow light will go on. If you want to keep going, that's fine. If you want, you don't get more than a cumulative 20 minutes, so you can use your time accordingly. The red light will come on when you exceeded your 20 minutes. We are being live streamed, so please keep that in mind when you're making any comments. Also, if you have any phones or other electronic devices, please turn them in the mute or turn them off so that they don't interfere with either your presentation or your opposing counsel or with the court. That being said, counsel, if you're ready to proceed, approach the podium.
All right. Good morning, Your Honors. May it please the court, my name is James Dinkins. I represent the appellant Florida PACE Funding Agency in this appeal, and we are fine with 5 minutes for rebuttal.
Okay, thank you, counsel.
This court should reverse and remand the order denying the petition for writ of mandamus for one simple reason. The court below based its determination to deny mandamus relief solely on the failure to prove irreparable harm. But irreparable harm isn't an element of a mandamus cause of action. Even with the elements met, mandamus is still an extraordinary writ, correct? It is, Your Honor. So it's still a matter of judicial discretion? Not necessarily, Your Honor. A writ of mandamus must be entered if the elements are met. It's not something that's left to the discretion of the trial court. If there is a mandatory statute and a ministerial duty that has to be performed, mandamus is the appropriate remedy, and it's a requirement of mandamus is the appropriate remedy. I'm not sure I agree with you on that requirement. And my understanding is that it is still the subject of judicial discretion. Thus the extraordinary nature. So, Your Honor, I think that there is the level of discretion that a court has with respect to extraordinary remedies is different based on the extraordinary remedy. For instance, in certiorari, there is always the element of discretion because there are components that have to be managed by the trial court, like irreparable harm, that would that sort of go to the very nature of judicial discretion. But just by nature of being an extraordinary remedy, mandamus doesn't require the exercise of discretion by the trial court. It's merely a determination of whether those elements are met, whether there is a clear legal right, an indisputable ministerial duty, and a lack of adequate remedy at law. The mandamus cause of action, and if you look at the cases, I think that this is, it sort of becomes clear from the body of cases, is there because that is the only way in some instances to compel compliance with a law that requires the performance of an affirmative duty by a ministerial officer or an officer with that ministerial duty. If that is left to the discretion of the trial court, we could have situations, as in the one here, where there is a validly imposed assessment, where the statute clearly requires that the tax collector collect that assessment, and where the tax collector has said, because I have a policy disagreement with the imposition of the assessment, I will decline to fulfill my ministerial duty. So if we leave that to the discretion of the trial court in a mandamus action, that essentially allows either the tax collector or the trial court to substitute their judgment for that of the legislature, which has said this is a ministerial duty that the tax collector must do. Unlike in other types of extraordinary relief, the discretion with respect to mandamus is cabined by the availability of the remedy to compel compliance with a ministerial duty, and that's sort of what makes it extraordinary. If you look at, for instance, an injunction, where the elements would be a clear legal right, that's the same as in mandamus. An inadequate remedy at law, that's the same as in mandamus, but there's an irreparable harm component to it. Instead of, as in mandamus, that irreparable harm is replaced by the ministerial duty. And the
Irreparable harm phrase first get introduced in this case?
So the phrase irreparable harm appeared one time in the petition for writ of mandamus as a sort of supplemental or additional factor, a persuasive factor. Is a motion to dismiss. It wasn't actually a response to the alternative writ of mandamus in this case, claimed that irreparable harm was not proven and therefore mandamus was inappropriate. That's the first time that the argument that irreparable harm was a component of the relief requested came into play, was in Mr. Roberts' response. And then,
did you not, in your petition, did you not assert that the plaintiff would be irreparably harmed absent issuance of a writ of mandamus?
it was asserted, but that wasn't a component of the relief requested. It was in the nature of providing context. The petition for writ of mandamus clearly laid out the three requirements, that is the clear legal right, indisputable ministerial duty, and inadequate remedy at law, treated those separately. And then in the additional discussion, in the argument portion, we sought to enhance the persuasive nature of the petition and the writing therein by saying that we would also be irreparably harmed. That was never an element that was argued or offered even. It just appeared the one time, almost as a fleeting reference or something that was not necessarily even to be used as a term of art.
But the trial judge picked up on that, for lack of a better term, and discussed that fairly regularly during your combined hearing on the merits and the motion to dismiss.
So I would agree.
And nobody said, "Hey, Judge, stop for a second. You're barking up the wrong tree. There's no requirement of irreparable harm here, and if I led you astray in my petition, that it wasn't intended. These are the three elements that we need to focus on." And then the judge could have said, "Oh," I guess he could turn to opposing counsel and say, "Is that right?" and then go forward. But it seemed like the judge, throughout the whole process, believed that that was the primary topic of discussion vis-a-vis your evidentiary burden, didn't he?
We 100% agree that that is what the judge focused on for the entirety of the hearing.
And he wasn't dissuaded from that.
Well, we had presented prior to all of that happening in sort of the opening remarks, the argument that we do here, that there are three elements to mandamus: clear legal right, indisputable ministerial duty, and inadequate remedy at law, and that's what we needed to prove. And then the judge said, "But what about irreparable harm?" and started asking a lot of questions about that. The preservation aspect of it is simply that we had to have made the trial court aware that this is what we believed the correct standard to apply would be, and if the judge then chose to ask questions, focus on something else, as an attorney, your job is to make the best of the situation as it arises. In a more common preservation case, for instance, if there's an objection to the introduction of evidence and that objection is overruled, the attorney is not required, in order to preserve the error, to pretend as if that evidence didn't come in. You still have to try to persuade the trier of fact.
Isn't the attorney required to proffer the evidence so that we as an appellate court can then look and say, okay, that judge overruled this objection, the attorney is arguing here on appeal that that was an erroneous ruling and therefore we should reverse the judgment adverse to the appellant, and we would look as an appellate court to say, well, what was the evidence that would have come in if the objection was not overruled, or, no, I mean,
I think we've gotten twisted, but I believe I understand your question, Your Honor.
okay.
Yes, in the case where the...
Sustained, actually, would have been, but anyway.
Right.
My point being is, it has to be made clear what it is, the context as to why there was an error.
Well, absolutely, Your Honor, and I think that's actually a really good example, because if you look at an evidentiary error where evidence is offered, the objection is sustained, and that evidence isn't presented to the trier of fact, then yes, a proffer would be, in most cases, required.
I agree, that's what I meant.
But in a case where an objection is made and overruled, and the evidence does come in, there's the need for a proffer is obviated because the evidence
I
is
agree
there.
with you, I apologize.
And I think in this case, we're much more analogous to the overruling of an objection, because we did make the argument, both in the writing and in the hearing, that there are only 3 elements to mandamus, and they are clear legal right, indisputable ministerial duty, and inadequate remedy at law. The fact that the trial court, at the invitation of the appellee, chose to focus on this 4th aspect that isn't a part in any other case addressing mandamus relief of irreparable harm is something that, as a trial attorney, you have to say, okay, this is what the trial court needs to know and answer the questions that the trial court is asking.
The judge also focused on the adequate remedy at law.
Not that.
Action.
Correct, Your Honor, but there are numerous cases that indicate that a declaratory action isn't an adequate remedy for something that could be compelled in mandamus relief. And there are a couple reasons for that. The primary one is that a declaratory action simply makes a statement of the law, and a mandamus action, if the writ is issued, does compel performance. It is more akin to an injunction than a declaratory action, and that was argued at the trial court, specifically that there is already a declaratory action at function on file here. In 2022, the Florida PACE Funding Agency obtained a bond validation which very clearly states that the tax collector in each county in Florida where the agency imposes assessments is required as a ministerial duty to collect those assessments. The appellee here chose to ignore that ruling or claim that it didn't apply. Subsequent to the sort of the operative facts in this case, that the appellee also, along with a number of other counties and tax collectors, challenged that by way of a motion for relief from judgment under Florida Rule of Civil Procedure 1.540, 363 days after the entry of the judgment, and that was denied during the pendency of this appeal. That denial itself is on appeal to the Florida Supreme Court right now. So that's the context, I think, here, is we have a situation where the appellee has refused to comply with a clear binding court order, and at this point that he has participated in attempting to set aside and failed to do so, and is saying, well, I don't want to comply with that, and so therefore I'm not going to collect the assessments that the circuit court in the bond validation judgment said it was my ministerial duty to collect. So that declaratory action, I think, indicates that, or is really exemplary of the fact that a declaratory action isn't adequate relief where a party seeks mandamus, and that's something that is echoed by the court in, I can find where I marked it here and give you the exact quote. Was it Plius, I believe? Yes. So in Plius versus Chris, this is a Florida Supreme Court case from 2009. The court says, we reject the argument that an action for declaratory judgment in the circuit court is an adequate legal remedy under the facts and circumstances of this case, which would then require the denial of a writ for mandamus. So I think that the precedent is that a declaratory action isn't sufficient. And as we discussed, the elements for mandamus relief, or for injunctive relief, are also different in that they do require that adequate remedy at law, although they can be against anybody, not just an officer, with a ministerial duty. It's not the same. And in Mandamus, the harm is, and this is a little bit of theory, but the harm is presumed by the fact that you have a statute commanding an officer to perform an action, and the officer hasn't done that. It's that violation of the ministerial duty assigned by statute or by general law that sort of supplants the need for irreparable harm.
So if that failure to perform the ministerial duty can be characterized as a harm, and there's no other adequate remedy, then how is it not irreparable? How are those two things not synonymous? I realize there's case law that treats them differently, but the way you're describing them, you're describing the same thing with two different terms.
I think that in a way, when we look at any cause of action, we can break down the elements into some components that bear similarities. So when I'm comparing an action for injunctive relief with an action for mandamus relief, we can say here are the similarities. The difference is we call something irreparable harm here, where we're testing the harm to the parties itself, and of course there's the equitable and discretionary function in an injunctive relief. But then in addition, on the mandamus side, one, you lose that equitable component. It's still a case in equity, but there's not a balance of what is the public interest. That's already been done by the legislature. And while we could say that arguably the irreparable harm is met or satisfied, and we in fact did argue this at the trial court, by the violation of the statute, it is in fact a different standard. I'm not sure if that answered your question, Your Honor, but we'll try our best. I believe I've covered most of what I wanted to here. Again, mandamus is simple. It is a clear legal right, an indisputable ministerial duty for which there is no inadequate remedy at law. There is no requirement that anyone prove irreparable harm, and yet in the trial court's order denying the petition for writ of mandamus, the only statement as to the facts was petitioner was given notice and opportunity to present evidence in support of its writ of mandamus and failed to present evidence of irreparable harm to entitle the petitioner to mandamus relief. It is very clear that the trial court found that mandamus was not appropriate because irreparable harm had not been proven. It was something that was preserved.
When that order came out, did you alert the trial judge that we don't have to prove that? Was there a motion for rehearing or anything else done?
There was not a motion for rehearing, Your Honor. We wanted to, and again, these assessments were not collected, and we're still in a mode, and now that we're a subsequent tax year in, there were 129 assessments that were entitled to be collected. Mr. Roberts collected 39 of them, and that meant 90 were uncollected by the tax collector. There were some voluntary payments, but about $80,000 still from 2023 is outstanding, and that is continuing. We presented that evidence, which I would argue is sufficient to show irreparable harm, although it is monetary damage. It's not something that we would be entitled to get from the tax collector. The tax collector does not have the duty to pay the assessment on someone else's property. But the trial court did not feel that that was irreparable harm and therefore denied relief. Because irreparable harm isn't an element of mandamus relief, because this was preserved, and because even if it wasn't preserved, it was a fundamental error, this court should reverse and remand, and I will reserve the remaining 3 minutes and 40-ish seconds for rebuttal.
Okay, thank you, counsel.
Thank you.
Yes, sir. Whenever you're ready.
Thank you, Your Honor. May it please the court, Peter Webster for the appellee, Will Roberts as the Volusia County tax collector. I'd like to address first, Judge McIver, your comment, or rather your question in which you asked counsel for pace, whether we weren't just using two terms to mean the same thing when we talk about no other available adequate remedy and irreparable harm. And in fact, in the injunction area, all that irreparable means with reference to harm is something that can't be adequately dealt with by an action at law. The two terms are, in fact, the same. And it's perfectly clear from the transcript of the hearing in this case, which, by the way, we supplemented the record with, that everybody involved in this case was using the term irreparable harm as shorthand for the issue of whether there was another adequate remedy available. With regard to the bond validation hearing that Pace contends establishes both their clear legal right and the tax collector's clear legal duty, the fact of the matter is much of what you just heard today is not part of the record, and it was certainly not presented to the trial judge, because I'm talking about the subsequent proceedings in Leon County challenging the extraneous information in the bond validation order. That whole case that's now on appeal to the Florida Supreme Court had not been decided at the time the petition for writ of mandamus was filed and heard. And so that's an issue for another court. It's in the bosom of the Supreme Court. I think the briefing is either nearly complete or complete. I fear that case is not going to go well for Pace, but it's irrelevant for purposes of this case. So I'd like to talk first about whether error occurred here. Counsel for Pace said that the use of the term irreparable harm occurred at the invitation of the appellee. They've said that in their brief too. The fact of the matter is, in its emergency petition, Pace said that an action for declaratory relief would take too long to be effective, and thus it had no other adequate remedy at law and would be irreparably harmed absent issuance of the writ of mandamus. That's where irreparable harm originated. In our motion to dismiss, we simply responded, there will be no irreparable harm because other available remedies could deal with the situation that was the subject of this complaint. It's clear from the transcript of the hearing that the trial court's concern was whether mandamus, which, by the way, is an extraordinary discretionary writ, whether it was appropriate and necessary in this case, or whether some other remedy, and the trial court repeatedly referred to a declaratory judgment action, would provide adequate relief here. During the portion of the hearing addressing Roberts's motion to dismiss, the court said to Pace's attorney, the first thing you have to prove is that this is an emergency and appropriate for writ of mandamus. I think you alleged irreparable harm. The attorney responded, we did, and the court said, why don't you tell me what you thought that was? And the attorney for Pace then discussed irreparable harm at some length, using the term repeatedly over the next 6 pages of the transcript. After the evidentiary portion of the hearing, the court again asked Pace's attorney, is this case appropriate to be a petition for writ of mandamus, or should it more appropriately be a declaratory judgment action? Pace's attorney said, we're very comfortable with being held to the evidence because the evidence clearly establishes that there will be irreparable harm. At the conclusion of the hearing, the trial court found that Pace had failed to meet its burden of proof that there would be any irreparable harm that could not be compensated by some type of monetary action down the road, or that would not or could not be resolved in a declaratory judgment action. Clearly, all the judge was saying is Pace had failed to satisfy its evidentiary burden to demonstrate there was no other adequate remedy available. And they've not challenged that finding on appeal. Instead, they claim the judge held them to an additional elemental burden that's inappropriate. And that you can tell from the judge's oral statement of his determination that's not what happened here. And all the written order does is memorialize that. So it's simply disingenuous to say here that anyone in the trial court during the hearing on this was under the impression that irreparable harm was a separate element that Pace had to prove in order to be entitled to mandamus relief. But even if that's true, that error was clearly invited. And let me start by saying in their reply brief, Pace says the invited error doctrine applies only when the appellant is the one who first invites the error. That's just not the law. We cited the law in our answer brief. We cited a case from this court, 2015 decision Alexander versus Quill Point 2 condominium. And in that case, this court held that the invited error doctrine applies whether the error was invited solely by the appellant or by the appellant and appellee together. The reason for the invited error doctrine is so that the trial court won't be held responsible for error that it was led to commit by the litigants. So, during the hearing, Pace's attorney repeatedly suggested that Pace was required to prove irreparable harm and that it had met its burden. Pace's attorney used the term irreparable harm 16 times during the hearing. At one point, Pace's attorney said that an element Pace had to prove was whether there is a remedy at law, and that irreparable harm goes beyond something that can be resolved through monetary damages. At another point, he said, the irreparable harm comes in 3 flavors. At yet another point, he said, we are very comfortable with being held to the evidence because I think that the evidence clearly establishes that there will be irreparable harm. And finally, in response to the question from the court, whose burden is it to show irreparable harm and what is the standard? Pace's counsel said, it is Pace's burden to make a showing of all 3 of the elements, and every shred of evidence that you got today was that irreparable harm is occurring and is continuing to occur. Those are just classic examples of invited error. While we believe there was no error, if there was error, it was certainly invited by Pace. However, even if you conclude that it wasn't invited by Pace, that it was error and that it wasn't invited by Pace, it's clear this error wasn't preserved, and it's certainly not fundamental error. This appeal presents precisely the kind of gotcha argument that the contemporaneous objection rule is designed to prevent. In Williams versus Lowe's Home Centers in 2008, this court said that the contemporaneous objection requirement was designed to prevent a litigant from allowing an error to go unchallenged so it may later be used to a tactical advantage. Clearly here, if Pace had either objected to the court's use of the term irreparable harm when it announced its ruling that Pace had failed to carry its burden to establish it couldn't be adequately compensated by some sort of monetary action, or that the dispute couldn't be resolved by declaratory action, or Pace had filed a motion for rehearing, raising that same issue in response to the court's written order. Clearly here, the court would have clarified what it intended to hold and said, all I intended to say was that you failed to prove that no other adequate remedy existed. Pace failed to do either, and by doing that, if there was an error here, it deprived the trial court of the opportunity to fix that problem, and it shouldn't now be permitted to benefit by taking advantage of its failure to raise this in the trial court. And Judge Harris, you're clearly correct. The law in, I think, all of the districts, but certainly in this district, is that when an error first appears in a final order, in order to preserve the right to raise that error on appeal, it must be brought to the trial court's attention by a motion for rehearing or other appropriate motion. And we cite this court's case. We also cite a significant case from the first DCA, BT versus Department of Children and Families, in our answer brief. Now, in its reply brief, and here at the end of its argument, Pace asserts that even if it wasn't preserved, this is fundamental error. Clearly, this is not fundamental error. The case BT versus Department of Children and Families, which I just mentioned, which is cited in our answer brief, discusses the doctrine of fundamental error at some length. And it tells us that fundamental error that may be raised for the first time on appeal is error so grave that it deprives a party of due process of law. That is, and this is according to the BT court, Judge Tannenbaum, I believe, wrote the opinion. When we talk about deprivation of due process of law for fundamental error purposes, we're talking about deprivation of fair notice and a real opportunity to be heard and defend in an orderly procedure before judgment is rendered. Fundamental errors to be used rarely and very guardedly. I suggest to your honors that here it's simply absurd to argue that Pace was deprived of either fair notice or a real opportunity to be heard. On the contrary, it had every opportunity to present precisely the same arguments to the trial court that it's now presenting to this court. It simply chose not to do so. And the result was a classic gotcha. To allow Pace to rely on fundamental error on appeal would require ignoring the basis for the rules on preservation of error, that basis being basic fairness in the operation of the judicial system. And it would also require ignoring the principle that fundamental error applies only to error that is so grievous as to constitute a miscarriage of justice. We don't have anything remotely resembling a miscarriage of justice here. What we have is a gotcha. So for all of those reasons, we suggest that this court should affirm this case is without merit. It frankly borders on frivolousness.
But before you close,
Yes.
would you be willing to briefly touch on my initial question and my understanding, right or wrong, that an extraordinary writ like Mandamus does not issue as a matter of right, but upon the discretion of the judge?
That's correct, Your Honor, but the discretion is not as wide-ranging or uncabined as it might be, for instance, with other extraordinary writs. If all three of the elements are proven, including the element that there's no other adequate remedy available, then the scope of the trial court's discretion is relatively narrow.
Well, that to me would seem to suggest then that when the elements are met, that this extraordinary writ does issue as a matter of right, which is specifically contrary to the language the Supreme Court has used in describing the extraordinary writ.
Well, I think the best description, I think, Your Honor, is in the case involving former judge of this court, Judge Pleiss, in the Supreme Court opinion that was cited to you.
Pleiss?
The opinion is Pleiss versus Christ, and it's at 14 Southern 3rd, 941. In it, the Supreme Court describes the scope of the remedy, and among other things, they say that to be entitled to the relief, the petitioner must prove 1, 2, and 3. In that case, the Supreme Court rejected the argument that a declaratory judgment action was an adequate alternative remedy based on the facts and circumstances of that case, which clearly means that it's a factual determination, and whether there's another available adequate remedy is a factual determination. The burden is on the petitioner to prove that. The trial judge here found that Pace had not proven that, and Pace is not challenging that finding on appeal. Rather, it's arguing, I think, clearly without any basis, that the trial court imposed an additional burden of proof not required by Mandamus.
We're taking a trip down memory lane here. The Supreme Court telling our Governor Chris, you need to pick Lambert or one of the other people on the short list of that JQC.
Yeah, exactly, Your Honor. If there are no other
Bob
questions.
Boyce retired and he wanted to leave and they need to appoint a successor. Oh, well, nice to
Thank you, Your Honor.
Thank you, counsel. And to leave it to Governor Scott to appoint me. So. That guy, Jacobus, actually.
I make sure that I'm using my own time and not Mr. Webster's
I'm sorry.
here.
Just a minute. I'll
Don't want
get you
to.
back on the clock there.
Don't want to go over here. Again, thank you, Your Honors.
Yeah, go ahead.
Want to address a few points that were brought up. The first is the case Alexander was cited for invited error. That case does not address invited error, but instead excusable neglect, which is a different standard and obviously a different set of circumstances. The error in this case was first brought up by the appellee, and then it was clear that the judge had latched onto that and began asking questions about it.
But you pled irreparable harm, though. I mean,
we stated it, and I think in the section of the petition that was just read here, it's clear that these are the additional factors, something to urge treatment as an emergency or on an expedited basis, which the judge, in his discretion, ultimately denied. That was not about the fundamental aspects of the Mandamus case, which in a separate section of the petition and earlier on in the petition were clearly stated. The other case that I wanted to discuss is Plius again. Obviously, that's one of the best cases that we have on Mandamus. And in Plius, the statements about Mandamus relief is that a petitioner is entitled to Mandamus relief, not in the discretion, but is entitled to Mandamus relief if those three elements that we've been discussing exist and are proven. That's the same thing that happened in Pizzi versus Scott, a very similar situation. This is a table disposition, unpublished, but a petitioner is entitled to relief under this court's authority to issue a writ of mandamus when those three elements are met. So while all extraordinary remedies, all extraordinary writs sort of are wrapped under the umbrella of being extraordinary and therefore discretionary, the case law establishes that that mandamus is, once those elements are proven, something that the petitioner is entitled to. It's not within the trial court's discretion to deny it once those elements are met. I do note that the case law, particularly Supreme Court cases that are asked directly, will often say, we believe you're entitled to the writ, we're going to withhold issuance because we believe that you're going to comply with the law, and that's something that is fairly consistent when talking about public officials. For just one more minute, irreparable harm and inadequate remedy are not the same thing. If they were the same thing, they would not be two separate elements of an injunction action. They're something different, and while it may or may not be true that the trial court believed an inadequate or irreparable harm was the correct standard or a replacement for inadequate remedy, the irreparable harm, if you look at the transcript, was something beyond just the existence of an inadequate remedy based on the questions that the trial court was asking. It is not somehow failure to preserve an error to simply respond to that question and to understand that the judge needs to do that in order to grant relief. The point is to win at the trial court level and not have to be here on appeal. So going with that, the judge's inclination there is simply an effort to do the best work for a client. There are a few other things that I could state, but I'm out of time, and so I would simply encourage this court to reverse and remand with instructions to use the correct legal standard for mandamus.
All right.
Thank you.
Thank you, counsel. All right, we'll stand adjourned. There's Bob Ployce right over there in the far right corner looking down on all of us.
All right.